So let's talk about the city attorney and management of legal services. This will apply to just about all of you. There is, of course, in some of your charter cities, Seattle being the most obvious, where there is an independently elected city attorney. But in most of the cases, the city attorney has a responsibility to represent the city, and the city, like any kind of corporate form, is represented by a person who speaks with authority, the CEO, mayor, or council. And that creates conflict from time to time, as it gave rise to this 1997 Attorney General opinion that focused on this issue and reminded cities that in a code situation, law vests the power of government in both an elected mayor and an elected council. And in this respect and in others, the law contemplates that the mayor and the city council will act together on behalf of the city. This isn't a hypothetical situation. It was Benton City a few years ago, where it was such a crisis that the mayor had went out and hired his own lawyer and brought that lawyer to council meetings, and the city council said, no, the city attorney that we hired and is under contract with the city is the city attorney, and so you had two city attorneys supposedly at each council meeting. Finally, it was resolved when the mayor was taken out of office and the issues were resolved. But you do get into that dispute when the council may think that the city attorney is not being responsive to the council's requests. Do you have the authority to independently hire counsel on occasion? The answer is yes. And that was addressed in the Tukwila versus Todd case back in 1977, when the mayor wanted to pay the clerk more than the city council had authorized in the budget. And Mayor Todd said, no, we're not going to do that. We're going to pay the clerk more. And the city council separately hired a lawyer to sue Mayor Todd to stop him from paying the clerk more than the budget had approved. City attorney represented Mayor Todd. That's the city attorney's primary lead in that situation. In this case, the council won. Found that Mayor Todd had acted improperly in seeking to pay the clerk more than the clerk's position was authorized. And as a result of that, the court authorized the council, the city, to pay the council's lawyer the attorney fees necessary to bring this action against the mayor. But in a case involving the town of Steilacoom, where the council sued the mayor to enforce a decision of the council regarding a development approval, the court ruled that the council had been wrong. It did not have the authority to adopt the ordinance, and the mayor was correct in not following the direction of the council. And as a result, the attorney who had been hired by the city council was not paid by the city. Don't know who paid that lawyer, but it was not the town of Steilacoom. You could distill this lesson to a very simple one. If you as a council want to hire outside lawyer to challenge something that the mayor is doing, if you're right, the lawyer gets paid. If you're wrong, the lawyer doesn't get paid. Hopefully you'll never have to encounter that particular situation.